at the moment with wills, because obviously wills cover you when you die, but lasting powers of attorney will cover you whilst you're still alive, but have perhaps lost capacity to manage your own affairs.
Okay.
So people get mixed up between executors and attorneys. An attorney's job is to manage your bank accounts, your bills, everything else, your property, whilst you're still alive, but as I say, when you're not able to do that yourself. So they differ slightly to general powers of attorney. You can do the same thing with a general power of attorney, but that would come to an end if you lost capacity. A lasting power of attorney will go beyond that point.
Hence the word lasting is literally.
Suggests,
so a normal situation would be then that it would cease to be when that person.
The general power of attorney, comes to an end, so you can appoint anybody to do anything for you any time if you want to, whilst you've still got capacity.
Yeah.
But if you just do it by way of a general power of attorney, then, as I say, once you lose capacity, it would cease to have any effect.
Wow. Right.
So,
Okay.
as the name suggests, a lasting power of attorney goes beyond that point. So once you've lost capacity, you can continue to act for that person. Okay. So it's an important distinction. In fact, I've just done a general and a lasting power of attorney for somebody, two actually recently, because the lasting powers of attorney unfortunately take so long to get registered with the Office of the Public Guardian.
Yeah, I remember you mentioning this. Yeah,
so they're not valid until they're registered, and it was the need was more immediate for the person concerned.
Yeah.
Because they were selling their house and they wanted their son to be able to sign for them. So we did a general power of attorney for him to enable him to do that, but then also did the lasting power of attorney so that he still had something in place to cover him if he then lost capacity later on down the line. Okay. And we've just done it for another chap now as well. So general powers of attorney are still very useful, but obviously they're no good if you have a stroke or you have an accident or something, and then so we'd always suggest that if you're going to do the one, then do the both. If you need it more immediately, then definitely do the general power of attorney.
Okay.
But yes, the lasting power of attorney. So you choose who you're going to appoint to manage your affairs for you in that event. It can be your children. It can be whomever you want. We would usually suggest if you're going to appoint just one, then at least appoint a replacement.
Right, okay.
Because once it's registered with the Office of the Public Guardian and it's valid, if you lose that one attorney, you'd have to go through the whole process again, doing a lasting power of attorney, appointing an attorney. At least if you've got a replacement, then they can step in if your primary attorney dies or isn't able to act for whatever reason. An alternative to that, if you wanted more than one, is you can appoint more than one.
Right.
Nothing to stop you doing that.
Okay.
You can appoint as many as you want, in fact. Obviously, it makes it a little more difficult to manage if you've got more than 4, for instance.
Absolutely.
But yes, if you've got 3 children and you wanted to appoint all 3, there's no reason why you can't do that.
Okay.
And what is useful is you can appoint them either jointly, which means they all need to act together. Or you can appoint them jointly and separately.
Perfect. Okay.
Which means one or other of them can act, or they can all act together. So that's the one that usually people go for. Because if one or other is on holiday, then at least the other one can
actually make decisions.
And more importantly, God forbid one of them dies, at least the other ones can still continue to act.
Absolutely. So, and this is really prevalent in these days, isn't it? Because this is what we talked about before. That yes, we're all living longer, and isn't that great? But the downside of it is that we've also got an awful lot of diseases that are coming along, which we never even talked about in the past.
No.
But
unfortunately, the number of people I get coming to me now who have already been diagnosed with dementia. And I think the medical profession who are a lot hotter on this now as well, saying as soon as you get the diagnosis, go and see a solicitor, get a power of attorney done. We see a lot of people who have been diagnosed early stages. They've still got capacity.
Of course they have.
Question of that. But yes,
there are signs there.
There are
to
signs
say the
there,
least.
and they've been to the GP, and the GP has said, "Well, I think now's the time to go and get a power of attorney done." And it doesn't mean it has to be used straight away. I have to point that out as well. It doesn't mean that it has to be implemented straight away, so that suddenly your right to sign on your own behalf is taken away. That's not what it's intended for. It's intended to cover you only when you've lost capacity.
Okay.
In fairness, they can be very useful even when you've still got capacity. So if you're laid up in hospital or something and you need somebody to nip down the bank for you or whatever, they can be useful from that point of view as well. So you don't have to limit it to mental capacity.
Right.
You can say that it's still effective once it's registered with the court, in which case it's valid from that point onwards. The other option is to say that it's not valid until you've lost mental capacity. What I would say is be very careful if you're using that option, because it may mean that your attorneys have to produce medical evidence every time they
want to use it.
Because if the bank looks at it and say, well, it says here that it's only if you've lost mental capacity, where's your evidence that you've lost mental capacity? and you may need to do that every single time you want to use it. So we usually say guard against doing that, make it valid once it's registered with the court.
Yeah.
And then it's ready to go. And the intention is, as I say, it's not going to be used until you've actually lost capacity anyway.
Right.
But at least it's ready to go if you need it. There is one other person involved in this, and that's what's called a certificate provider. And that is a person who signs it to say that they're satisfied that you've got the capacity to do it, that you haven't been unduly influenced when you've done it.
Yeah.
So nobody's held a gun to your head and made you do it.
Yeah.
And they don't take any further involvement. They're literally just signing to say that yes, as far as they're concerned, you've discussed it with them, and they're happy that you understand it, and that nobody's putting undue pressure on you to do it.
And this has got to be a person, you mentioned before about children being the ideal. If not children, whoever it may be, it's got to be completely and utterly trustworthy, don't they? More so than probably any other scenario, really.
Yeah, well, your attorneys can be family members. Your certificate provider's got to be somebody independent. So a good friend or even a professional person can do it for you.
Ah, right, okay.
Obviously, a professional person is more likely to charge.
Yeah, of course they are, yeah.
So a GP, in some instances, we usually recommend, particularly if there is a diagnosis of dementia or some such, because obviously it's important that we're satisfied that the person understands it before we go any further with it. But they are very important documents nowadays. The days when you used to be able to wheel your aunt or uncle into the bank and say, well, there's a signature.
Absolutely,
long gone.
Absolutely.
If there's any suggestion that the person's lost capacity, the first thing the bank or the building society or whoever is going to ask for is a power of attorney.
Of course they
if
are.
you haven't got it, the options are somewhat limited then. Particularly if you've gone past the point of having capacity to do a power of attorney.
Of course, yeah. Too late in the day
it's
then.
too late in the day, and
course,
it then falls upon the person who wants to start acting for you to make their own application to court to be appointed what's called a deputy.
Okay.
It's a similar role, but as I say, the onus is then on that person to make the application to the court, and then for the court to say, yes, you're an appropriate person to act. They will then grant an order, cutting the whole process down to very simplicity, but they will grant an order appointing you the person appointed to manage that person's affairs. And it's changed recently in the last few years. Actually, it used to be that you could only apply for one person to be appointed a deputy. Nowadays you can have more than one.
Right, okay.
So in the same scenario, if there's 3 children, the 3 children can apply to act again jointly and severally.
Severally, yeah.
Unfortunately, that process is far more expensive. You have to pay an application fee to the court of £400 before you even start on solicitors' fees and everything else.
Wow.
You also need to get a medical report as well to say that that person has lost capacity, to convince the court that they're no longer able to manage their own affairs before the court will even consider an application.
Goodness me.
So again, you've got another fee that then has to be paid to the medical professional.
Yeah.
You have to do your own declaration if you're the person applying, to convince the court that you are a suitable person to be acting.
Right.
So, for instance, if you're bankrupt,
Yeah.
you're convicted of a criminal offence.
Anything that would otherwise deter,
Yeah. And then last but not least, you have to fill in another quite lengthy form which details the person's assets, their liabilities, their income, anything you can possibly imagine. They want to know from the court's point of view, so that they can determine, whether this is a suitable case for appointing a deputy to manage those affairs.
Wow.
The one thing I would say is if your assets aren't great, then I wouldn't probably bother going for the deputyship application. I had a lady in the other day and her aunt only had about £3,000, and I said, really, it's not.
No, of course it's not.
Doing the amount involved.
Yeah.
So the cost can be disproportionate.
Yeah.
Again, all the more reason to do a lasting power of attorney.
Yeah.
I think the application fee to the court is £82 at the moment.
Yeah. And it was more expensive in years gone by, was it not?
Yeah, it used to be £110, the application fee alone.
Okay,
and then you were paying £400 to do
That's right, I remember.
Nowadays they've come down quite a bit because we've all got used to the application, we've all got used to doing the forms. So we charge £250 plus VAT for doing a lasting power of attorney. That includes doing the document for you, making sure it's signed correctly because it has to be signed in a specific order, and then actually lodging it with the court, getting it registered, and providing you with copies. So it's the whole
Kit and caboodle.
Precisely.
It is indeed. It is indeed. It is. Right.
I was thinking of the suitable words.
Indeed. No. DJ talk. DJ talk. Right. Okay. We're going to play. Actually, the first one is we're going to play 2 songs back to back. And the first one is actually one of Vicky's choices, which is Sam Smith's I think it is his latest song, isn't it? It's his latest, isn't it? Too Good at Goodbyes, followed up by Too Late for Goodbyes by Julian Lennon. There's a theme going on there, isn't there? We're not quite sure why, but there we go. We'll be back in a few minutes after listening to these two. His voice is absolutely superb, isn't it, Sam Smith? That was great, yeah.
Back on form, isn't he?
Why? Did he